A very good evening to all of you. Welcome back to the live virtual classes of ICAI on CA Intermediate. As you are aware, we are discussing incorporation of company and matters incidental thereto. And our paper is corporate and other laws. In that, this topic we are covering. We have already, taken one session on this, which you people had attended, and you had a number of questions. And it is quite encouraging to have those particular questions. Some of the questions which I could not answer in our previous session, we'll be doing it right now. As a customary thing, we should basically go ahead with a recap of the session quickly. So this benefits the students who have not attended the previous session, as well as it will give a quick recap to the students who had attended that what we all covered in our previous session. If you see, we had discussed one important aspect. We began with the promotion of a company and what is the utility of that promotion and what is the position of a promoter. And you people had a number of questions relating to the fiduciary responsibility of a promoter and what this fiduciary responsibility is. And you would recollect, we talked about the Erlanger's case and we discussed that doing any secret profits or not disclosing information to the company before it gets incorporated is not a right thing. And that is something which is deprecated by the law. So this is very important aspect which we discussed. We also discussed the role of a promoter and its personal liability. We also briefly discussed about the pre-incorporation contract, and particularly with reference to the Specific Relief Act, we said that after 1963, there is a provision under the Specific Relief Act, which now provides for a mechanism to, permit the pre-incorporation contracts by the companies. Someone of you had a question, what is the Specific Relief Act? So Specific Relief Act was enacted in 1963, and objective of this law is to enforce the contracts, the specific reliefs wherever they are mentioned. So you don't, because we are having students across India, I believe, and this is the common language which can be utilized for them. Now let us come down to the section 3 that we discussed about formation of a company, and we were talking about different types of companies, right? और उसके special requirement के बारे में हम बात कर रहे थे, all special requirement and incorporation and exemptions as well. We also discussed section 3A, which basically dealt with members severely liable in certain cases. Particularly, you will note where the membership number goes down the statutory minimum, that is 7 in case of a public company and 2 in case of a private company. And in relation to one-person company, we saw specific additional compliances which are there. We also saw section 7, that is incorporation of a company, and we basically saw what are the required documents, which are the important list of documents. That is what we saw. We also looked at briefly about the procedural requirements, particularly the SPICE E plus forms, that is INC 32. We talked about INC 1, INC 7. And we also discussed about MCA 21 portal, which is basically an online mechanism to register the company. Then we discussed section 9, that is effect of registration. So the moment the company gets registered, it is a separate legal entity. And we saw a few examples to understand that how the company is a separate legal entity and what are the things which it can do, including possession of an immovable property, tangible and intangible property. It can sue, it can be sued. All these things we have discussed. Then we also talked about declaration on commencement of business. So there are certain declarations which needs to be made for commencing the business. And in particular, if you are talking about sectoral regulators, you require permission from sectoral regulators. Like in case of a banking company, you would require a permission from RBI or a license from RBI. Similarly, for insurance company, it is IRDAI, like that. Then in our session, I gave you plenty of additional information. So you have to be conscious. You refer to your BOS material, which is shared with you people already as a syllabus, what will be coming in your course. But where I am teaching, I am giving you some additional information which is related to that information, which makes your understanding more deeper and more related so that you can remember those particular things very clearly. And that is why I'm giving you those examples, right? That is the format which we are following. What I have done now is in my slides, I have added additional word in red so that you can identify that, yes, this is an additional information which you choose to read more, or you can just read that and then leave it there. We had a couple of questions and clarifications towards the end, and I answered most of them. Promoters, specific relief, I've already answered. And then, you talked about list of INCs, so that is already available in the rules. And foreign banks, there was a question about HDFC. HDFC is not a foreign bank, HSBC is, and couple of others are there as a foreign bank. So this is what was the overall recap of the session yesterday on Monday, which we did. Now, let us move further and talk about today's agenda, what we are going to discuss today. But before that, there was a question on digital signature certificate or DSC, right? So one of you asked this question that how it happens. So for your information, this is again an additional information. The digital signature certificate or digital signatures are given by certifying authorities, and they are recognized under the Information Technology Act. And the objective of this digital signature basically is to encrypt a document. So say, for example, you are sending an MOA or Memorandum of Association for filing to the Registrar of Companies. Now, Registrar should be clear that this document is an authentic document. You have sent this document and he should be able to make you accountable. Just like when you do a registry and you sign physically, similarly, these documents, electronic documents which are filed, must be signed with digital signature. So digital signature certificates come in different classes. And as you can see, class 3 is utilized for e-tendering, e-governance, e-procurement, and internet banking purposes. I think for the DIN number, I think class 2 is sufficient. So what you do basically is you apply for a digital signature certificate and they give you this kind of a dongle, and which has got all your details. So whenever you have to do a sign, you have to plug in this particular dongle, and then whichever document you are signing, that generates a hash function. And this hash function is basically the computer-based number, as you can see here, and it gets encrypted. So beauty of digital signature is that it is unique to the document which you are signing. Generally, if you sign on a piece of paper, all your signatures are same, right? But in case of digital signature, every document's signature is different because it is customized to the document itself. So there are two things which happens. One, you encrypt the document and give a short form, and your signature is attached to that. And that becomes a digitally signed data. And when there is a verification, the person concerned will be opening that particular document, again applying digital signature, your public key. And then when he opens that, the document or the data which you have sent to the person concerned will come out. At the same time, the hash function will come out, which will show that this document has been sent by you or signed by you. So this is the overall perspective of digital signature certificate. Similarly, if you will see, there is a requirement of director identification number, which is very important for filing. Every director requires this before you come up with all the documentation. In fact, the promoter concerned, if he wants to become a director, then they also require subscribers. If they want to become a director, they also require director identification number is a very important number. And this is just like your Aadhaar number. It is generated only once for one person. You cannot have multiple like PAN. And it is interesting to note there is a quick trivia that the first DIN number was given to Ratan Tata. And as you can see, it was 00001. So that is how this thing is. So this is the information which I wanted to share with you. Now let me move further and talk about learning outcomes, which we will be talking about today. So, or we have already dealt with is the red ones, which we have discussed already. Today, we are going to talk about Memorandum of Association and Article of Association in quite detail. And then we also have a look at the different concept of registered office. I think these are the two things which we will cover today. and then the remaining one for the third lecture, and that is how we will complete this whole chapter. Coming back to another important point which we wanted to discuss before, or we had discussed, was lifting of corporate veil. And I told you that corporate veil can be lifted because the moment under Section 9, a registration certificate is given, registration basically gives you the, data. Registration provides you with the certificate, or it says that, yes, you are incorporated now as an incorporated agency. So it is a separate entity which it comes into. Now, for the outside world, as well as for all legal purposes, the company is a separate legal entity. It is an independent entity which is there. Now, however, there are situations when you need to catch hold of the people behind the company, right? And these situations may be by way of a statutory provision, which is given under the Companies Act, or it can be by way of a judicial intervention. So many a times Tribunal has got power, National Company Law Tribunal, wherein it can lift the corporate veil, or maybe High Courts or Supreme Court can lift the corporate veil. Or there are statutory lifting also. Say, for example, if there is an officer who is in default, then the law disregards the company. It keeps the company aside and catch hold of the individual who was in default, right? So the individual cannot take a defense saying that, okay, this was the work relating to the company. Now, that is not the situation. There are situations of vicarious liability and many other things, but we are not going into the depth of that. Similarly, if there is a fraudulent conduct of business, then also that is a situation which needs to be looked at. Similarly, fraudulently seeking investment, illegal acceptance of deposit from public, these are all situations in which the corporate veil can be lifted, right? So this is what we discussed. And there is one more interesting situation which I wanted to bring you forward, particularly in the context of insolvency and bankruptcy code, that now more so the corporate veil gets lifted if a company is in default. So once a company makes a default in payment of its debt, then its corporate veil gets lifted again. And you can see that at that point in time, the control of the company shifts from the company, that is the debtor, to creditors, right? And that is what creditor in control model is there for insolvency cases or corporate insolvency cases. So this is also a situation of kind of lifting of corporate veil, because what you do here is that the people who are having equity goes out, they don't have control of the company, and the control shifts to the creditors who have given a loan to the company. And what is the trigger point? Trigger point is non-payment of debt. So I'm sure you people will be studying this particular topic in quite detail, insolvency. So I'm not going to cover that here, but definitely lifting of corporate veil is a very important point. Now, let me take you to an important section which is there in Section 7. It relates to companies incorporated by fraud. So there is a provision under Section 7 itself. Subclause 6 specifically says that if a company is formed by way of fraudulent ways, or suppressing certain information, or furnishing false information, or giving suppressing material fact, in all those particular situations, if there is a fraud, by way of a fraud, the promoters or the people who have tried to incorporate the company, or they have made a false declaration, then in these situations, everyone whosoever is concerned, I would say officer in default, or maybe promoter, or any other persons who have incorporated that company, will be punishable under Section 447, or there is an action which will take under Section 447, which talks about basically corporate frauds. Further, if you will see, there are certain more actions which can happen. So generally in these situations, either any person or maybe the registrar of companies or central government may make an application for passing such orders as the tribunal may deem fit. So when we are talking about tribunal here, it is National Company Law Tribunal, before whom the application is made. And then the tribunal, after looking at the circumstances, may order the following. So what all the orders they can give? They can give an order that the that the management of the company, including changes, if any, or maybe in the memorandum of articles of association in the public interest, may do like that. Okay, so it can order a change in the memorandum of association, articles of association, as it may deem fit. Similarly, it can give a direction that liability of members shall become unlimited. So that is one consequence which can happen if there is a fraudulent information or information which is suppressed is given to the registrar of companies while formation of a company. Or it can direct removal of the name of a company from register of companies. So you can see a tribunal can also direct that, okay, fine, remove this particular name of the company from the register. Or it may even pass an order of winding up of a company. Or it may pass such orders as it may deem fit. However, in all those situations, wherever these, adverse orders are passed against a company, they should be given a reasonable opportunity of being heard in the matter. And what is this called? Basically, do you remember any word, a single word where a hearing is required to be given? Yes. By what principle? Yeah. What principle requires the company shall be given a reasonable opportunity of being heard? Not perpetual succession, Ritika. Natural justice. Very good. So it is principle of natural justice, Nitish, and I think who answered? Yes, yes, it is Anirudh, natural justice, right? So principle of natural justice is very, very important, and you cannot condemn someone without being hearing them. So it is important for you to hear them. That is the requirement. Okay. Now, second is the if that is the requirement. And then section 447, as I told you, this is an additional information. If you have a look at section 447, it is talking about severe penalty. So as you can see here, we are having the definition of fraud, and it is quite similar to the Contract Act definition of the fraud. And it says basically the fraud in relation to a company's affairs includes any act, omission, concealment, or abuse of position committed by any person or other person with the connivance in any manner. So it is a detailed definition. I would suggest you people to have a look at it, because I think this is not part of your syllabus. But since we are talking about 447 in section 7, so briefly you should have an idea. But you can just focus on the penalty amount, see how huge it is. So any person who is found guilty of fraud involving an amount of 10 lakh rupees or 1% of the turnover. So 447 gets triggered only when the amount of fraud is 10 lakh rupees or 1% of the turnover of the company, right? Generally, it is like that. However, in specific situations, like for example, section 7, it specifically mentions 447. So this clause does not apply. So irrespective of the amount, whatever amount may be involved in that particular transaction, it will get triggered. 447 gets triggered, right? So I hope you got the difference here. Further, what is the penalty? Penalty here is that the person whosoever is concerned will be imprisonment for 6 months, but which may extend to 10 years. So you can see the punishment for this is about 10 years, corporate fraud. And similarly, provided when fraud in question involves public interest, the term of imprisonment shall not be less than 3 years. So it will not be 6 months. It is a cognizable offense then, wherein minimum 3 years punishment will be there. Similarly, if the company is involved, then in that particular situation, the the people who are in helm of the affairs will be punished with a term of 5 years, and for a fine which is about 50 lakh rupees. Now, previously it was 25 lakh rupees, or with both. So this is the overall, section of 447. Now, let us move ahead and talk about another important, form of a company which gets incorporated, and that is basically the Section 8 of the company, which is licensed by the central government. So any company which gets incorporated requires, they have to follow the Section 8, provisions. And then, yes, Aditi, what is this NPO? Okay. So if you see, wherever the central government is satisfied, that a person and not one person company, not one person company, not one person company or an association of persons. Yeah, not profit organization. Okay, that is quite interesting. There are so many abbreviations. I thought that you were talking about something else, NPA or something. Okay. So here, section 8, what is the requirement? Requirement here is that the central government, here in this case, central government is registrar of companies. So you will see that central government is used in company law at many places, right? At some places, it is used as registrar of companies. At some places, it is used as regional directors. So depends that what kind of a gravity of work it is. Accordingly, the delegation of power is given to central government, ROC, registrar of companies or regional directors. I hope this is making sense to you people. Now, here for the purposes of section 8, the central government is registrar of companies, and registrar of companies can give the permission, or you can say, to open a section 8 company if the object of the company is basically the promotion of commerce, arts, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such other object. So this is what is the requirement of object clause, right? So object clause has to have these things rather than any profit. So there should not be any profit, right? And that is what is a second important requirement, which says it intends to apply its profit, if any, or other income in promoting its object. So, profit should not be divided as dividend. So intends to prohibit the payment of any dividend to its members. This is a requirement which has been talked about in this situation, right? Now, if we talk about and further speak to here, it is important that Section 8 company cannot write in its name the word limited, or as the case may be, the words private limited. These things cannot be written in Section 8 company, because these shows basically that it is a having a limited liability. Then the company registered under this section will not alter the provisions of the memorandum of articles except with the previous approval of the central government. So if you will see, the alteration of memorandum and articles is basically a prerogative of a company. It can do so at any point in time, but not with Section 8 company. Why? Because when the company gets incorporated, it gets incorporated by permission of the central government. So when you want to make changes in the main documents of the company, you have to again go back to the central government for the necessary permission. This is what is the requirement. Now, Section 8 company cannot be also converted into any other form. And if you require to convert them into any other form, there are special conditions which needs to be fulfilled, which is given in the rules. We are not going into that particular detail. But I just wanted to have a look at this CIN number. So as you can see in the CIN number, there is NPL. That is the word which is used. So it is not profit company. So that is something which is written here. U means what here? Can you tell me what is U? Unlisted. Very good. So it is unlisted, and then thereafter there is a code which is given, and then it is MH. MH means it is state, Maharashtra. Very good. And then there is a year, and then you can see the type of a company. That is how. So you are all clear with CIN, how CIN is. Very good. Now let us move ahead and talk about the other requirements as far as Section 8 company is concerned. So you have to fill again same INC 32, and there are some additional requirements which are there. So the application for registering the company under Section 8 shall be accompanied by the following documents. These documents are necessary for incorporating a Section 8 company. That is, memorandum and articles of the proposed company. Definitely, those memorandum and articles of association will have specific provisions. Then the declaration by an advocate, a chartered accountant, cost accountant, or company secretary in practice that memorandum and articles of association has been drawn up in conformity with the provisions of Section 8, right? So you have to specifically show that everything has been done as per the order. Okay. Just give me 1 minute. Just, take it. Yes. So this declaration is important because these are intermediaries and they have a responsibility. An advocate, a chartered accountant, you people are all preparing for chartered accountant. You will have a huge responsibility because you are an intermediary. Government also relies on you. Everybody relies on you. The company also relies on you. While your duty is to serve the company and help the company, but at the same time, your duty is also under the law towards, being fair and giving information rightly. So this is very important aspect. Similarly, it goes with company secretary in practice. So they have to give a declaration. So this is something which will satisfy the registrar of companies that yes, everything has been met properly. Though they will do their own investigation, but at the same time, they require this particular declaration, right? Then if you will see an estimate, this is an important aspect which needs to be declared at the time of registering Section 8 company. That is an estimate of future annual income, that how much it can generate, as well as expenditure of the company for next 3 years. So basically, they have to prepare an action plan for next 3 years, that what all things they will be doing, what would be their sources of income, from where the money will be coming, what would be the object of expenditure. And that is very, very important for Section 8 company. You may be aware that the government has been of late very strict as far as the NGOs are concerned, and there have been there have been regulations which have been brought because previously we were not aware where from the funds are coming, and these funds were utilized for multiple activities which were not in conformity with the law. So that is something which they have brought into picture. So now, similarly, this particular provision is a very important aspect wherein this estimate has to be given. Then comes, and before giving the permission, definitely central government will have a look at it, all these particular things. And a declaration by each of these persons making the application, whosoever is making the application under Section 8. Now, if you see this provision further, you will find that the revocation of Section 8 license can also happen if there is a false information which is given to the, registrar of companies while registering them, right? So central government, this power is delegated to regional director. So any who can give you the license, it is registrar of companies. Who can revoke? It is the regional director in case of Section 8 company. So any company which contravenes any of the requirements of this or the conditions section subject to which the license is issued, because many a times when license is issued, they may impose some conditions or certain requirements, so that they have to follow. And the affairs of the company are conducted fraudulently or in violation of the objects of the company, prejudicial to public interest. These are the terms which are used. So in those situations, they have to, follow the requirement, and the license may be revoked, right? Now, what happens if the license is revoked? Because it is a Section 8 company, it is not a profit company. So there is no occasion that whatever money has been collected will go back to the members who are part of it. So generally what happens, there are two methodologies or two ways by which this can go. The money, excess asset, whichever is there in a Section 8 company, will either go to another company registered under this section, another Section 8 company which is having similar objects subject to the conditions. Say, for example, there is a company which is a Section 8 company which is focusing on sports, right? So it may happen that if there is a fraudulent activity conducted by that Section 8 company, then while winding up or while revoking the license, the asset, if there is anything remaining, may be transferred to that particular company. And who will make the decision? Definitely, regional director has to make that decision. Or the the excess asset may be sold and proceeds, whatever comes, will be credited to the insolvency and bankruptcy fund, which is formed under section 224 of the Insolvency and Bankruptcy Code, which is generally utilized for running, the insolvency activities. So this is a very, important provision where you can see that the money which has come up will be, or the existing company, if it has to be revoked, then it will either merge into another company or it has to be sold out, and whatever money comes will be going to insolvency and bankruptcy fund. Now there are penalties also. So there is a punishment if license is revoked and there is found that there is a fraud which is involved, or there is an incorrect information by which the Section 8 company came into existence. The company, may be fined from 10 lakh to 1 crore rupees, or people who are behind that, director or officers, will be fined 25,000 to 25 lakh rupees. This is what is the requirement of the sections. So this is about contravention. If there is any contravention as far as Section 8 is concerned, whatever requirements are there, that needs to be met very, very clearly. Any questions as far as Section 8 company is concerned? Any one of you? If you want to ask any question, you can ask here. Yes, people have raised hand. You can ask, please, question. You can ask. Yes. Hardik, Karan, and Satish. I hope you have got the permission to open your mic. No? Okay, let me open it for you. Yes, Sanatan, you can go ahead. This was.
Hello, sir.
Hello, sir.
Yes.
Sir, can you explain fine once again? In case
Which
of
one? Fine.
Section 8.
Okay.
Yes, sir.
Okay. Okay. Satish. Yes, Satish.
Section 8 company can pay salaries to those members, their members. Salaries.
Yes, they can.
Section 8 company can, they can, sir.
They can pay the
But
salaries to
only-
the members. Yes.
Okay, sir. They do not pay dividend to members.
No, dividend is not paid, but if there is a salaried employee, then definitely they have to be paid.
Okay, sir. Okay.
Right. Because they have to run the business, no? Yeah. Karan. Karan.
हेलो सर,
Yes.
कंपनी जैसा कि इसमें दिया हुआ है, कंपनी विथ 10 लाख एंड 1 करोड़ विल द अमाउंट विल बी फाइनेबल टू द कंपनी, और उसके जस्ट नीचे 25,000 से 25 लाख डायरेक्टर्स और जो भी लोग उसमें इन्वॉल्व है, तो ये दोनों अलग अलग होता है या एक ही अमाउंट में आता
नो,
है?
दोनों अलग अलग है। एक लाइबिलिटी जो है वो लीगल एंटिटी के ऊपर लाइबिलिटी है, कंपनी के ऊपर, और एक लाइबिलिटी इंडिविजुअल लाइबिलिटी है। जो लोग भी उस कंपनी के पीछे हैं, सेक्शन 8 कंपनी के पीछे, उनकी इंडिविजुअल लाइबिलिटी है। से फॉर एग्जांपल, करण एंड हार्दिक, बोथ ऑफ यू ओपनड अ कंपनी, सो कंपनी सेक्शन 8 के ऊपर एक अलग लाइबिलिटी हो गई, और हार्दिक की इंडिविजुअल लाइबिलिटी, करण की इंडिविजुअल लाइबिलिटी एज डायरेक्टर एंड ऑफिसर्स अलग हो गई, जो कि 25,000 से 25 लाख हो सकती है डायरेक्टर एंड ऑफिसर्स के केस में। कंपनी के केस में वो 10 लाख से 1 करोड़ रुपए। Yes, Hardik.
Good evening, sir.
Yeah.
Sir, I want to ask that the fraud under section 447 is over and above for 25,000 to 25 lakh, or it is included within it?
No, come again.
Sir, the fraud under section 447 is over and above the value of that penalty, that is 25,000 to 25 lakh, or it is included in
No,
it?
it is under, it is basically when you are talking about fraud under section 447, it is under the 447, the provisions we are talking about here.
Okay, sir. So,
Yeah.
if 447 will be applicable, then this penalty will be given to them.
Yes.
And sir, I have one more doubt. Sir, I have a doubt in section 7, the first slide.
Yes. Okay. Go ahead. You can type your question in case you are not able to speak. Okay, give me a second. Yeah, Hardik, you are muted. You can just, type your question. I'm not able to unmute you. There's some problem. Section 7, someone asked a question. What was the question? You can just type. Yeah, section 447, there can be multiple kinds of a fraud, So corporate frauds, there are so many corporate frauds which keep happening. Say, for example, a company is formed to run an illegal business. That is kind of a corporate fraud, Or say, for example, somebody has given a wrong document. The declaration has been to be done, but they have given a wrong document. Or say, for example, somebody has submitted a wrong invoice of 10 lakh rupees, GST invoice. Or maybe they have submitted a bill or which is a false bill. Recently, you must have seen some examples in the public domain. I cannot discuss it here, but they have been tried or prosecuted for a wrong, invoice or a bill to the company. Say, for example, a travel bill, a wrong travel bill has been given. They have not traveled, but they have given, bill to claim the bill. And then when during audit, it was found that, okay, these are false bills. So these are all fraud cases, right? So this is the example of different types of frauds which are there. Well, now let me move further. I will stop again for questions. So you can, in the meanwhile, you can see all penalty amounts. I don't know what kind of questions you will get, but generally you should have it in your mind. If you there is a way of learning all these penalties together. So you learn it by way of a chunking. So whenever you are learning penalties, you learn it with every penalty together. Then you will remember. Otherwise, you will always get confused. Or you have to do a earmarking with the with the section or maybe with an instance. Then it becomes easy for you to remember that dimension, right? Change of name, we will talk about it when we are talking about alteration of memorandum. So we will discuss that all kinds of changes, whichever it is. So definitely there can be a change of name of Section 8 company also. But again, as I told you, the process to be followed here is you have to again go back to the central government for the necessary approval, right? Okay. One person cannot create Section 8 company, Shruti. This we have already discussed before in OPC company. Okay, now let me put you on hold, but you can always, type your questions here. I will have a look at it and then we will talk about it. Let me take you further in these slides. There is a section 10A, which talks about commencement of business, and there is a requirement of filing certain documents before the business gets commenced. And it is interesting to note that this was initially in section 11, okay? So it was omitted in 2015. However, later on, it was believed that this is an important provision and it should be there. So it was brought back as 10A. That is how you can see in the provisions. So what does the provision say? It says that a company incorporated after the commencement of Companies Amendment 2019, this is the Amendment Act, which actually introduced 10A, and having a share capital shall not commence its business unless what they should have to do, a declaration is filed by the director within 180 days of the incorporation of the company in the respective form. Basically, it is INC 20A, wherein the declaration has to be made. That register that every subscriber to the memorandum has paid the value of the shares agreed to be taken by them on the date of making such declaration. So, within 180 days, every share has to be made fully paid up. That is what is the requirement if we read and interpret this provision, right? So it is saying basically that give 180 days and make it. There should not be any situation of unpaid shares or in particularly for specifically the subscribed capital. We will discuss in detail when we talk about share capital. We will discuss these provisions of authorized capital, subscribed capital, paid up capital. These things we will discuss in detail at that point in time. So park that for now, but just understand it from the perspective right now that if somebody has agreed to subscribe to 10 shares worth 1,000 rupees and they have paid initially 500 rupees, within 180 days, they need to pay the remaining 500 rupees. And this declaration has to be given to the registrar that everybody whosoever has subscribed to the memorandum has paid the value of shares which they have agreed at the time of incorporation. I hope this is clear to you. Then if you will see, the company has to file with the registrar a verification of its registered office. It is very important clause, and we will see about this in quite detail in our next slides. Then there is also a requirement of approval from sectoral regulators before they commence the business. This I have already told you. Say, for example, if it is a banking company, then they need to give a permission or you can say approval from the Reserve Bank of India about their company. Similarly, if you will see, if you they are an insurance company, they have to give the declaration from IRDAI. Similarly, if you will see, they are a telecom company, then TRAI probably. There are many sectoral regulators. Every sectoral regulator needs to give them that permission, and then only they can commence the business. So then naturally so. So if there is a liquor business, say for example, they need to have a permission from the Customs and Excise department precisely. So this is a requirement which is there under Section 10A. Any questions on Section 10A? Any one of you? You can put it in the chat box. Okay. Now let's take you further and talk about the forms. So there are different forms. So whenever there is an incorporation of a company, INC means incorporation. Somebody asked this question yesterday. Incorporation forms. And with effect from 23rd January 2023, all incorporation forms are required to be filed in version 3. So now MCA 21 portal is in version 3 now. So if you will see, there are 10 forms which have been migrated to V3, and this phase migration is done to smoothen the MCA 21 portal. You can see this is the screenshot of MCA 21 portal. I suggest each one of you to please visit the MCA website. That will give you a plenty of information. These are the different forms for incorporating a company, and these are called incorporation sets. Like for example, Spice E plus Part A talks about reservation of a name. Similarly, Spice E plus Part B talks about the other details which has to be filled in for incorporating a company. And these two parts, Spice E plus is known as INC 32. So under INC 32, Part A and Part B is there by which you can fill in these forms. Then there is Run, which is basically registering the names of the company. So that is the form for that. Then there is INC 13, which talks about Memorandum of Association. Then there is INC 31, 33, 34. These are all AOA, EMOA. Then there is INC 9, which talks about declaration. And then there is something which is called Agile Pro S, which is basically the consolidated form for, I will tell you, it is quite an interesting name. So if you will see, this is these are the fees, but just a second. Yes, Agile Pro S is basically includes GST. It includes, taxation number. It includes all other different other forms are there, which are mentioned in Agile Pro S. So there is a consolidated document which actually lists and tells you about each of these particular forms. So as when we are talking about incorporation, I suggest that you should have a brief idea about these particular forms, because when you go through this form, you will see there are plenty of things mentioned there. Probably couple of forms we will go through in our session just before the break. I will try to lead you through some of these particular forms, right? These incorporation forms in examination, they will not, come in detail of explaining these, forms. But briefly, they may ask you, if you talk about incorporation of a company, these forms should be there in your, mind. Like, for example, URC one, when you are talking about it, is unregistered company form 1. And Agile Pro S is, yes, automatically all forms are filled. Nowadays, every form is, pre-fill facility is there in the system, MCA 21, if you look at it, right? So this is the overall perspective of the forms, right? Give me a second. V3 is version. Okay. V3 means version. And somebody asked run. It is run. It is basically unique name. Okay. So registering unique name. So you have to have a unique name. So reserving unique name is called run. And that is called run service. Okay. Now let me take you to the slide back. I think I have answered the questions. Any other question here? All right, no questions. Okay. Now, let us talk about the fees. So as I told you before, all these particular forms, there is a requirement of some fees which needs to be paid. So you can see in this particular chart, till 15 lakh, there is no fees. And after 15 lakh to 50 lakh, you can see there is 51,000. This is a fixed fee for OPC and small companies. Like this, there are fees which are there. And on the basis of number of members also, there is some fees which is there. So you don't have to remember these fees. I just showed it to you so that you also have a look at it once. Okay. That gives you a understanding that how it works. So you should not be, confused later on. So this is the requirement. Now let us move ahead and talk about what I will do is you are having a number of questions on forms. So the FAQ is there. There is a consolidated FAQ. I will upload that particular thing in your portal. Okay. So you will get those particular documents, all of you. And I have already uploaded the presentation on your portal. I hope you people have got that portal, your presentation, yesterday's presentation, right? Yes. Okay. Now let me talk about this. Dishika, you are right. It is section 366 URC is related to that. Okay. Now let us move and talk about constitutional documents of a company. So you all know constitution is the Grundnorm. We call it basically, it is the basic document. Nothing, no law in the country can go beyond the constitution. Everybody has to adhere to and agree to understand about constitution. No law can go beyond constitution. Similarly, in case of companies, there are two basic documents which are also referred to as constitutional documents of a company. And these two documents are, one document is called memorandum in short, and all places it is referred to as memorandum. And it means basically memorandum of association of a company, either framed originally or subsequent amendments to that document, right? And the detail about memorandum of association is given in section 4 of the Companies Act. Then the second constitutional document is Articles of Association of a Company, AOA, and it is given in section 5 of the Companies Act. And it basically is a detailed document. A memorandum of association is a not that detailed document. There are differences between these two are that the basic document of formation of a company, which tells you about the major things, is memorandum of association. Article of association talks about implementing those things which is mentioned in memorandum of association, how you will implement that. So this is the article of association. Now there is section 6, which says basically that though memorandum of association, article of association are constitutional documents, but nothing in these two documents can go beyond the provisions of the Act. So everything has to be within the provision of the Act. So memorandum of association cannot put some clause which is contrary to or conflicting with a provision under the company law. Similarly, article of association cannot have a provision which goes against memorandum of association and company law, right? So article of association can even not go beyond memorandum of association. So memorandum of association, so how, just imagine it, at the larger periphery is company law, then under that is memorandum of association, and below that is article of association. So this is how it works, and anybody cannot go beyond the provisions of the Companies Act. So this is something which is very important. And particularly section 6 subclause B, if you will read, it says any provision which is going repugnant to the provisions of the Act shall become void. So it will not exist at all. So one has to be very careful that their memorandum of association, their article of association does not go beyond the provisions of the Act. Now let us go ahead. Yes, I think Apurva Das has a question. Well, Apurva, I think you are jumping the gun. Okay, jumping the gun is a provision under the Company Law, Competition Act, basically. Search for it. It is quite interesting. Yes, it is given in your study material. We will talk about it, Apurva, right? Okay, now let us go. It is not intraviral, it is intravires. Let us talk about a doctrine that is called doctrine of constructive notice. So you people we have talked about effect of registration, right? So whenever a company gets incorporated, it gains a separate legal entity. This is something which we discussed. Now, memorandum of association and articles of association are the two documents which are filed with the registrar of companies. These are also available in the company's registered office. So if someone wants to have a copy of these documents, the company is supposed to give that particular document on the requisite fee which is there, right? So any member who wants to have a copy of the articles of association, memorandum of association, they will be available to you. Nowadays, due to electronic age, everything is available in an electronic mode. You have to just search and you will get those particular documents. Now, if you will see, what is doctrine of constructive notice? Doctrine of constructive notice is basically a doctrine which assumes that anybody who is dealing with a company will have the knowledge of the contents of its public documents. And which are the public documents? The two public documents are Memorandum of Association and Articles of Association. These documents are publicly available with the company as well as the regulator, and online. If it is a listed company on the stock exchanges, all this information is available. So it is expected that anyone whosoever is dealing with a company must have notice to these documents. So it is the responsibility of the person or the vendor or the creditor who is dealing with these companies to take note of these documents. So if something which is contained in these documents goes against a creditor later on cannot come and say that, okay, fine, I was not aware about it, right? So ignorance of law is no excuse. So here doctrine of constructive notice basically says that anybody, whosoever is dealing with the company, must know about memorandum of association and article of association. So what it indicates? It indicates that anybody, whosoever is dealing with a particular company, must read their MOA and AOA. I don't know how many of the vendors are reading this, but this is what doctrine of constructive notice says. However, basically, if you will see, this doctrine protects the company from the outsiders who may claim that they were not aware about internal rules, etc., etc. However, the doctrine works in favor of the companies, but at the same time, what it is trying to do, it is basically shifting the responsibility to the third party to investigate company's capacity to enter into a transaction. So it is responsibility of the party who is entering into the transaction with the company has to be clear about it through the memorandum of association. However, there is an exception to this, and the exception to this is referred to as indoor management rule, or it is also referred to as Turkand rule because it was laid down in the case of Royal British Bank versus Turkand, 1857. And what happened in this case? In this particular case, there was a loan which was sanctioned, and the provisioning of that particular loan said that loan may be taken by the loan may be taken by the directors on the bond issued to them, provided that there is a meeting which approves that particular taking of loan. In this case, the directors took the loan from the bank, however, on the bond. However, there was no authorization by the company in the meeting which was required to be done. So the court in this case said that, okay, fine, they had the bond and they took the loan on the basis of the bond. Internally, whether there was a meeting held or not held, this is something which bank is not supposed to inquire into a very, detailed way, because it is the internal management of the company. Everybody will not go into the nitty-gritty of the things. And that is where the exception to the doctrine of constructive notice was laid down as indoor management rule, which again protects the third party, right? So this is the doctrine of indoor management. Now, doctrine of indoor management has also some exceptions, right? So for example, if you will see, there are certain exceptions which are there of doctrine of indoor management. Like, for example, the person who is dealing with the company is aware or is suspicious of the transaction. Then in that situation, they should cross-check. No, they should not rely that it happens that way. So it is important for them to cross-check that. This is an exception. Similarly, in case of fraud, agar fraud hua hai, then in that case, you cannot say that indoor management rules should apply and we should be given a leeway. So somebody has asked me a question in Hindi. I don't know what to do with that, but I will try to answer you, Manu. I don't know what your Anuj, I don't know what your other teachers are doing. Let me cross-check this with ICAI, but I will explain you for now. So if constructive notice आपको समझ में आया, अनुज? Are you able to understand what is constructive notice? Constructive notice ये कहता है बेसिकली कि हमने मेमोरेंडम फाइल कर दिया, आर्टिकल्स फाइल कर दिया, ये दो डॉक्यूमेंट होने के बाद कोई भी अगर उस कंपनी के साथ डील कर रहा है तो उसकी ड्यूटी बनती है कि वो मेमोरेंडम पढ़ के आए, आर्टिकल्स पढ़ के आए. डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट इसका एक्सेप्शन है. डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट ये कहता है कि ओके ठीक है, हम ये पढ़ेंगे, लेकिन हम निटी-ग्रिटी में नहीं जाएंगे, बहुत डिटेल्ड में नहीं जाएंगे उसको समझने के लिए. जैसे कि इस केस में हुआ, तुर्कांड्स के केस में, कि ऑथराइजेशन था कि आपके पास अगर बॉन्ड है तो आप उस पर लोन ले सकते हैं, प्रोवाइडेड देयर इज अ रिजोल्यूशन विच इज पास. कोई रिजोल्यूशन पास हुआ है, राइट? देन इन दैट पर्टिकुलर सिचुएशन, उस सिचुएशन में बेसिकली इन्होंने एक्सेप्शन लिया कि भाई कंपनी ने रिजोल्यूशन पास किया कि नहीं पता नहीं, लेकिन इसके पास बॉन्ड था और ये डायरेक्टर ऑथराइज थे, तो जो ये इंटरनल इनका जो मीटिंग होना था और उसका अप्रूवल लेना था, ये वो प्रिज्यूम करेंगे. दिस इज व्हाट is the requirement of doctrine of indoor management, right? So this is what is the difference. Now let me move ahead. If we go bilingual, then it will go. It will be very slow. So excuse me. What I can do is you park these questions, and during the break, I will answer all the question in Hindi, whatever you want. Okay, 15 minutes break we are having. So all people who are in Hindi, they can stay back. I will answer all your questions in Hindi. Okay. Park your questions there. Now, let me move ahead and talk about section 4, which talks about memorandum, right? So, memorandum is the major document. This is the main document of a company. And if we talk about memorandum, memorandum has been defined under section, we have already seen that definition. And if you see section 4, it talks how memorandum should be. And if you see memorandum of association, it has got 6 major clauses. Okay. And we will talk about these clauses one by one. So the first clause which is talked about here is talking about name of a company. So memorandum must have a name of the company with the last word limited, in case if it is a public limited company, or the last word private limited in case of a private limited company, right? So these are the two important things which you should remember. So wherever you find only the word limited, that means it is a public limited company. Where it is private limited, that means it is a private limited company. In case of one-person company, it has to be written one-person company on the name. It has to be displayed, not in the name of the company, but on the board, the name board or registered office board. It has to be written clearly. Now, you have to also mention the state in which it is registered office of the company is to be situated. Third is the objects for which the company is proposed to be incorporated and any matter considered necessary in furtherance thereof. Then there is liability of members of a company, whether limited or unlimited. Then in case of a company which is having a share capital, one has to mention the amount of share capital which the company is to be registered, division of the shares, and the fixed amount and number of shares which the subscribers to the memorandum are taking. That is something which has to be mentioned. Nobody can take less than 1 shares. So you can see the memorandum, all memorandums, you will have some amount of shares, not less than 1. And then in case of one-person company, we have already seen there is a requirement of a nominee, INC 3, I think, that they have to fill the nomination form. And then there is a subscription clause. So whosoever are signing the memorandum, they are called subscribers of the memorandum. And what is the requirement of subscription in case of a private company? Come on, tell me. What is the requirement of a subscription in case of a private company? How many people should subscribe to the memorandum? 2 members. Very good. And in case of a public, Pranav, 200 will not subscribe. So when a company is formed, they just require 2 members. And generally, these are 2 members which are mentioned there. Okay. In case of public, this is the 7 numbers. Okay. Maximum people who can be there. So everybody will not sign in the memorandum because they have to give their complete data, Aadhaar card, PAN card, all these data has to be given when you are, signing in the memorandum. So memorandum, generally the minimum requirement is what people follow. Okay. Now, let me take you to the other provision, which says any provision in the memorandum of articles, in case company is limited by guarantee and not having share capital, then purporting to give any person a right to participate in the divisible profit of any company shall be void. So in case of all guarantee companies, there should not be any situation of a divisible profit. So because there is no share, right? So if there is no share, there is no question of dividing the profit as per the share. So this is something which is a very, very important aspect in the memorandum of association. Now, format of MOA. Somebody asked this question that why there is a purporting. Purporting means proposing. Okay. Purporting. Rashmi, purporting means proposing. Okay. Now, the memorandum are in different formats. So, Schedule 1 of the Companies Act, you will find that the memorandum can be in table A, B, C, D, and E. These are the 5 tables. And as you can see, each of these tables are representing the different type of a company. Like, for example, table A is meant for memorandum of association of a company limited by shares. Table B talks about memorandum of association of a company limited by guarantee and not having a share capital. Table C talks about memorandum of association of a company limited by guarantee but having a share capital. Table D talks about memorandum of association of an unlimited company and not having a share capital. Table E talks about memorandum of association of an unlimited company and having a share capital. So these are the different formats, out of which table A is the most common format. And I would suggest that each one of you should have a look at table A, what all things it contains. Particularly format of MOA, you will find it is a very short format. So you will come to know because it has got only 7-8 clauses. Okay. 6 main clauses and remaining 2 or 3 depending upon the company. Now, when we talk about MOA, so MOA name clause, this is the first clause, right? So first clause of a memorandum of association is name clause. And as you would note, this particular clause or this clause does not apply to a company registered under section 8, because in case of section 8 company, there is no requirement of private or public or limited. It has to be not mentioned there. Now, the name clause, it clearly says that the name of a company with the last word limited in case of public limited company and last word private limited in case of a private limited company. However, in case of a IFSC company, you have to mention International Financial Services Company. It has to be suffixed. So IFSC so-and-so company, IFSC so-and-so company in case of public and a private enterprises. Now, the name stated in the memorandum shall not be. Now, these are the requirements of the name clause. Name clause has got multiple sections or multiple regulation rules, you can say, which provides for detailing. So quite detailed rules are there as far as naming is concerned. So it says name stated in the memorandum shall not be identical or resemble too nearly to the name of an existing company registered under this act or maybe previous company law. So you should not be very, very close, right? So this is something which has been talked about. Then it says it should not be such that will constitute an offense under any law for the time being in force. So what could be an offense for the time being in force? It can be any situation like, say, for example, it's an obscene name, then that can be an offense. Or say, for example, there is a trademark and there is a violation of that, then that is a, offense. Or it is an undesirable in the opinion of the central government. So if it is an undesirable name in the opinion of the central government, it also cannot be registered. Now, if you will see, there are certain words or expressions which is also not permitted. Like, for example, local authority, corporation, body constituted by the central government or the state government. These cannot be put forward, and any other name which is, prescribed under the rules. Now, if you see and move further, these are the requirements of an undesirable name. So you can see there are a number of undesirable name clauses. Like, say, for example, if it is in violation of the Emblems and Names Prevention and Improper Use Act. So somebody is using national flag, or somebody is using President of India, or somebody is using India. These things cannot be used. Or maybe somebody is utilizing the name of a foreign country. Like, for example, United States of America. Somebody wants to have a company by the name of United States of America. Can they have it? No, because it is an undesirable name. Then it includes any word or words which are offensive to any section of people. Then that is also not permitted. The proposed name is identical to resemble limited liability partnership. So you can see there are a number of list which is given here, which is an undesirable name, right? So there are three clauses basically. One, names which resemble too nearly with the existing company because it will create confusion. Second is undesirable name. And the third one is the words and expression. Like in this case, words and expression, national, union, central, federal, republic. These are the words which cannot be utilized by the company for its names. So this is the name clause. Now, when you reserve the name, and after this reserving of name, we will have a break, right? Indian Oil is a PSU, and see what has happened is at that point in time, before this rule came up, these companies were incorporated, right? So Sahara India is not Sahara India. Actually, it uses the word Sahara India, but its name is different, okay? So this is the existing company independent. It depends, but it is a generic word. I think it has to be used along with some combination, Pallavi. So you have to also see under the Trademark Act whether that particular name can be, because generic name as a name of a company, right? So somebody, if it's put independent cannot be trademarked because it is a generic name. So what is the process? Process of registering the name is a person has to make an application in a form and they have to pay the fees of the name of the proposed company and the name to which they propose to change. So these are the two things which are covered. One, either you are naming the first time or you are changing the name. So whenever an application is received by the registrar along with the documents, they will reserve the name if it is available. For how many days? For 20 days from the date of approval, right? Previously, this particular new name registration reservation was for 60 days. Now they have reduced it to 20 days because 60 days is a long period. You cannot just block the name for 60 days because there are not plenty of names available. So they just want to put it across for 20 days. And then provided that in case of an application for reservation of name or for change of its name by an existing company, the registrar may reserve the name for 60 days. So for existing company, if there is a change in name, in those situations, 60 days can be provided, right? This is a important requirement. Then where after reservation of name, it is found that the name was applied by furnishing wrong or incorrect information, or the company has not been incorporated, reserved name shall be cancelled. So name will be cancelled. And they have to pay a penalty which may extend to 1 lakh rupees. So this is quite a heavy amount, right? So you cannot just register the name and enjoy. So it is not a situation like that, right? So if you apply for a name and you are not utilizing it within 20 days, then either it will be reserved only for 20 days anyways. But again, you incorporated, reserve the name, you incorporate, or company has not been incorporated, or subsequently, then in those situations, you are liable to penalty for 1 lakh rupees. This is a quite huge amount. Now, if the company has been incorporated, the registrar may, after hearing the company, they will be either directing them to change the name within a period of 3 months, after passing an ordinary resolution, or take action for striking off the name of the company from register of companies, or make a petition of winding up of the company before the tribunal. So these are the consequences wherever you are getting a name by furnishing wrong or incorrect information. So be careful whenever a registration of name is there. One has to be very, very careful. They have to provide all information correctly. They cannot keep this. IFSC, Isha, we discussed yesterday in quite detail. You can see the presentation. I have explained that. Now, let us move ahead and talk about, again, I think it is rectification of the name of the company. We will complete the name clause and then we'll have tech. So rectification of a name of a company is a independent section. Try to understand that this is different than, not different. In fact, this is another way of changing the name of a company. But this is not voluntary. This is an action which is taken by way of a registrar. So if you will see, many a times, if a company in its first registration, have registered a name which is wrongly registered. Either it can be a spelling mistake, or maybe they have registered which they later realized it was a trademark or a well-known mark. If something kind of a situation is there, then they can make an application, and the central government must have an opinion that there will be two identical names or it will resemble the two names, then it may direct the company to change its name. The company shall change its name to a new name as the case may be within a period of 3 months of issue of such direction. So this is a action which is taken by the central government whenever there are undesirable names. These can be situations in case of trademark violations also, well-known mark trademark violations also, where company changes its name and obtains a new name. Within 15 days, they have to inform or give this notice to the registrar along with the order of the central government, who makes the necessary changes in the certificate of incorporation and memorandum. If company is in default in complying with any of the directions given by the central government as far as this rectification of name provision under section 16 is concerned, there is a the central government shall allot a new name in such manner as may be prescribed, and registrar shall enter the new name. So if, say, for example, the person concerned of a company does not inform registrar for this change of a name, central government can directly get that name changed. So this is a power which they have. This is other than the power under section 13, wherein a company is having a power to get it changed by way of a change in the memorandum of association. So you can see section 16 provides an additional power to the central government to change the name or rectify the name of a company because there are similar kind of a name or there is a trademark violation. Such kind of a situation, central government can directly make the changes. Is it fine till this point, all of you? You are clear with this? Plus and Pulse chocolate. That is a good example, Kambeshwari. Thank you. Okay, so at this particular juncture, now it is 7:19. We will take a break of 10 minutes, I think. 10 minutes is fine with you all. So, or 11 minutes, you can say. We will meet at 7:30 now. 7:30. Okay. एक मिनट रुकिए, मैं बताता हूँ आपको. सेक्शन 10A बेसिकली डिक्लेरेशन की बात करता है. तो कुछ कंपनीज हैं जिनको अपना बिजनेस कमेंस करने के पहले कुछ डिक्लेरेशंस देनी होगी, और ये डिक्लेरेशन बेसिकली उनको देना होता है जैसे कि रजिस्टर्ड ऑफिस के बारे में, कि उन्होंने अपना रजिस्टर्ड ऑफिस खोल लिया है और इस जगह पे है, वो डिक्लेरेशन देनी होती है. अब जैसे कि कोई डिक्लेरेशंस होती हैं कि कंपनी, आपको बैंकिंग कंपनी खोलनी है तो आपको रिजर्व बैंक की परमिशन लगेगी. तो ये सारी परमिशंस आपके पास आ गई है, ये इंफॉर्मेशन देनी होती है. ये सारी डिक्लेरेशन सेक्शन 10A में मेंशन्ड है. तो कोई भी ऐसी कंपनी जिनकी रिक्वायरमेंट है ये सब डिक्लेरेशन देने की, अगर वो अपना पेमेंट ये डिक्लेरेशन अगर नहीं देते हैं तो वो वायलेशन करते हैं. तो ये बेसिकली अपना बिजनेस कमेंस करने के पहले उनको ये सारी डिक्लेरेशंस आनी चाहिए पहले. ये सेक्शन 10A बोलते हैं. ठीक है, बाकी आप पढ़ेंगे सेक्शन तो आपको क्लैरिटी आएगी. ठीक है भूमि, भावना. And we are talking about this rectification of name. My one simple question, what is the difference between change of a name in section 13 and section 16? Can anybody tell me what is the difference between that? You can use the chat box for answering that. Yeah. What do you think is the difference between section 13? Because the proviso says, provided that nothing in this subsection shall prevent a company from subsequently changing its name in accordance with the provisions of section 13. And what is section 16? Yes, Anirudh, you are right. So one is a company request and the other one is a RD order. Very true. So one is where central government notices this, that there is a requirement of a rectification of the name of a company. It may issue that particular order. Whereas section 13 talks about the voluntary change. The person, the board may decide that, okay, fine, we want to change the name. Then subsequently they can change the name, right? Okay. Now let us move ahead and talk about the second clause. Second clause talks about the state of incorporation. And it is a very important clause. Here you have to mention in which state the registered office of a company shall be situated. So in India, while incorporating a company, you have to go to a ROC, and ROC is attached to a particular state. In some states, you are having two ROC. Like, for example, if I'm not wrong, there are two states in which there are two ROCs. One is, can you type in your chat box, which are the two states where there are two ROCs? Tamil Nadu, very good, Pranav. And what is the other one? Maharashtra and Tamil Nadu. Very nice. So in Tamil Nadu, we are having, Coimbatore and Chennai. And in case of Maharashtra, we are having Pune and Mumbai. Now, if you will see, there are certain states which have got specific requirements. So if you are situated in a Bengal or Maharashtra or Tamil Nadu, there are certain additional requirements. Like, for example, in West Bengal, you need to provide a recent utility bill. That is either electricity bill or any gas bill or something like that you have to give, or lease agreement and a no objection certificate from property owner as proof of registered office. This is something which is an requirement, additional requirement in West Bengal. In Tamil Nadu, you can visit the ROC office in Chennai and Coimbatore, that I have already told you. But here also, there is one important thing of general knowledge which you should all know, is that it all also depends that how much is the state ease of doing business ranking well. Because people will invest in a state or will open a utility bill. Karan is basically or any utility service. It can be gas, electricity. These are all utility services. Okay. Water bill. These are all utility services. So these bills are generated by the authorities and they are given in the name. So that is what is utility service. So I was talking about the state ease of doing business ranking. So say, for example, if somebody has to decide which part of the country I want to open a business or registered office, they will definitely look for a state which is more business friendly, isn't it? So in India, after 2017, we started state ranking of businesses. And this is what we do. And you can see this is the ease of doing business ranking published by India Today Group of the different states. As you can see, the dark green are top achievers, and then light green are achievers, and then orange is aspire, yellow is aspirers, and then emerging business ecosystem is the orange one. As you can see, this shows you the ease of doing business ranking. So these are more friendly, business friendly states, as you can see on the basis of the color. So it is quite an interesting data, though it is not, important from your exam perspective, but try to understand that why this state of incorporation is important. For stamp duty, it is important because different states will have different stamp duty, which require to be paid. Now, or other requirements like in Delhi, if you want to incorporate, there is a requirement of Shop and Establishment Act, which has to be fulfilled. Then comes the object clause. And this clause of a memorandum of association is a very, very important clause, or actually it is the main clause of the memorandum of association. Otherwise, if you have a look at it, all clauses are important, but this is also, this is a very important clause because it tells actually for which purpose the company is incorporated or what is the object of the company. So the object for which the company is proposed to be incorporated, any matter considered necessary in furtherance thereof is referred to as the object clause. So in the proviso, they say that for IFSC company, the object clause is very, very specific. So it says specified IFSC public company shall state its object to do financial services activities as permitted under the Special Economic Zones Act. So their objectives of IFSC company cannot go beyond SEZ. So there are specific rules for them, special economic zone rules. They have to consider their objectives in line with that. Similarly, in case of a object clause of a guarantee or object clause of a Section 8 company has to be charitable objects, right? They cannot go for profit object. Similarly, if you will see in case of a special economic zone, they have to also comply with the licenses which have been given to them by the respective regulators. Like, for example, RBI, SEBI, IRDI, all these regulations they have to follow in case of IFSC company. Someone of you asked IFSC company, it is in International Financial Services Authority company, IFSCA. So IFSC company is basically formed in a special economic zone. Now, when we talk about object clause, the object clause are previously there used to be three parts of object clause in 1956 Act. Now, under 2013 law, the object clause has been simplified. So the object to be pursued by the company on its incorporation has to be mentioned, and these are few objects. And for doing certain things or facilitating these objects, the matters which are needed will be referred to as matters which are necessary for furtherance of objects specified in clause 3A. So there will be some initial major 4, 5, 7, 10 objects, and supporting objects will also be there, which will actually help in achieving the first 5, 7, 10 objects, right? So this is the object clause. Now, object clause, if you will have a look at it of different companies, I always suggest to my students that you should find a latest memorandum of association of any company, open it and have a look at the object clause, what is written there. And you will be surprised to note that this is a long list of objects which is mentioned. Everything which can be possible under the sun is mentioned there. So this is called elaborate object clause of companies. Now, most of the companies have that kind of object clause so that they are having more flexibility in operating the business or, diversify their portfolio. So all these possibilities are there. There is an important doctrine which emerges from the object clause, and that is referred to as doctrine of ultra vires, right? And this doctrine of ultra vires is very, very, can you elaborate this question, Hardik, the limits of a company? If you are mentioning the limits of a company is decided on the basis of the object clause, yes, you are right. So the doctrine of ultra vires came up, and what is ultra vires? Ultra vires is basically a Latin term which means beyond the powers. So in corporate law, it refers to basically the acts which carried out by a company that are beyond the scope of the powers which company has. And company draws the power from where? They draw the power from Memorandum of Association and Articles of Incorporation. So Articles of Association as well as Memorandum of Association, this is something which will give power to the company. So anything which goes beyond this Articles and Memorandum will be considered as a, not within law, and that will be considered as Ultra Vires Act. Now, let me give you an example. This is an example. All of you should have a look at it and tell me what should be the solution to this. Yes. So there is a Memorandum of Association of ABC Company Limited, which says that its object is to sell lend or hire railway carriages and wagons, carry on business of mechanical engineers and general contractors, purchase, lease, sell and work mines, purchase and sell as merchants or agents coal, timber, metal, etc. This is what is the Memorandum of Association saying, 4 major clauses. Now, directors of ABC Limited enter into a contract with another company, XYZ Limited, for financing the construction of a railway line in Belgium. Further, the company ratifies this act of the director by passing a special resolution. मतलब पहले they enter into it and then there is a special resolution. Subsequently, the company repudiate this contract. बाद में company इसको contract को नहीं agree करती है, saying that being ultra vires. However, wagon basically is you must have malgadi, that is called wagon. Okay. However, XYZ Limited sued ABC Limited for damages of breach of contract since the contract was well within the meaning of the term general contractors and the shareholders had ratified it. Is it a valid and legal contract? Ratify means something which they don't have a permission, they brought to the board, Aditi, and then they approve. That is called ratify. Ratification means approving something. Okay. Ultra vires, it is defined. It is beyond powers. Contract is void because it is not within the powers of the company. Pallavi, okay. Tanu says it is valid. Hardik has already given. It cannot be ratified by all the shareholders and it is void ab initio. Okay. No valid. Contract is ultra vires. Okay. Anirudh. Okay. Most of you have responded. Yes. So let me take you to the response. And if you will see, it is the Ashbury Railway Carriage case, 1875. And this is the landmark case in company law. And it actually solidifies the doctrine of ultra vires. So this particular case, establishes that in this case, it was held that the usage of the term general contractors is with reference to mechanical engineers. Hence, it need to be read with connection with the company's business. If reference is not made, then the company can make contracts of any kind and any description like marine, biotech, etc. Hence, the contract between ABC and XYZ Limited for financing the construction of a railway line in Belgium is null and void, as some of you have already answered that, right? So this tells you about doctrine of ultra vires. So doctrine of ultra vires means what? If some power is not available to a company in Memorandum of Association, the company cannot do those particular things, in actuality. And if they do that, then that will be void, null and void. Now, if you see here, in Ashbury case, Justice Keynes basically pointed out why this doctrine is important. And they said two things. One, that it protects the investors of the company, so they may know the objects in which their money is to be employed. So say, for example, if someone wants to, invest in a company which is sustainable. Now, in their objects, they mention that it will work for sustainability. Then that gives them a confidence that, okay, fine, they will be working for sustainability. Secondly, to protect the creditors by ensuring that the company funds to which they must look for payment are not dissipated. Dissipated means misused or vanished in an unauthorized activity. So this is something which Justice Keynes said in Ashbury case, why doctrine of ultra vires exists, because it wants to protect the investors. At the same time, it also wants to protect or give clarity to the creditors. There are some implied powers which comes by way of, Memorandum of Association, and that is not affected by doctrine of ultra vires. Like say, for example, borrowing or like appointment of directors. This is something which is there that is not required to be mentioned in the Memorandum of Association. That power is drawn. That is, but how it will be done, who will be done, how much it will be done, these are things which are mentioned in Articles of Association. However, there are some powers which cannot be implied. So you cannot say that, okay, everything is implied. Implied, general things or, the general things or general aspects are implied, but specific aspects have to be mentioned. Like, for example, power to use the funds for political purposes. This is something which is not permitted to the companies, right? And you have seen that in electoral bonds case. So here in this particular situation, you have to specifically provide for that particular power. But can you provide that? Because Companies Act does not provide. Companies Act has some restriction in 1956. In 2013, I don't think that there is a restriction. Now, power to sell and dispose of the whole of the company's undertaking is something which is, has to be provided specifically. Then if you see acquire any business similar to company's own business, this is also very, very, has to be provided specifically. Now, what is the effect of ultra vires doctrine? Effect of ultra vires doctrine is that whatever activity you have done beyond the powers of the company will be void ab initio. Void ab initio means from the beginning it will be void. You cannot make anything legal. Void ab initio cannot be ratified. Void from the beginning. So subsequent ratification cannot happen. Voidable contracts can be accepted, but void ab initio, no. Then somebody may file a petition for injunction. So they may get a stay order saying that company or its members or some people are going beyond the powers given to them in dealing with the company. Then there is a personal liability which will ensue. So what will happen? Say, for example, if company is not owning the liability, in case of Ashbury case, just see, who will be liable? The directors who have entered into the contract with XYZ company will be liable personally because they entered into the contract knowing that there is a power which they don't have, the company doesn't have, right? Similarly, acquisition of property that is ultra vires. However, whenever there is an acquisition of property which is ultra vires, in this situation, the property will still be there with the company. The company can deal with that particular property irrespective of the fact that that acquisition of property is done by ultra vires method. Why that is so? Because company's money is involved in that. Company, though it may be an ultra vires act, but company's money has already gone into that particular property. So the company gets power to deal with that particular property. This is what is the effect of ultra vires. Then directors personally are liable to third parties, as I already explained to you. This is the impact of the Memorandum of Association. Now, MOA comes the fourth liability clause. This is the fourth liability clause, and it is an important clause. So the fourth liability clause is basically, if you will see here, it is called liability clause, right? Injunction bhavna is basically stay order. Okay. Injunction means a stay order, right? Yeah. You talked about dissipated also. Dissipated means vanish away or dissolve or reduce in quality. Now, liability clause, the liability of members of a company, whether limited or unlimited, and it must also state in case of a company limited by shares, the liability of its members is limited to the amount unpaid. Nowadays, you know that within 180 days, they have to pay this. In case of company limited by guarantee, the amount up to which each member undertakes to contribute, right, to the assets of a company, in case of it is wound up, or if he is a member, or within 1 year after he ceases to be a member, for payment of the debts and liabilities of the company, of such debts and liabilities. So basically, liability clause tells you about the apportionment of liability in case of debt becomes due or in case of a winding up, right? So this is the requirement of liability clause, and it has to be mentioned in the Memorandum of Association. No, Omkar, it cannot be ratified. Ultra Vires Act cannot be ratified. So the only way there is basically to amend the memorandum. Say, for example, you'd want to do something which is not mentioned in your memorandum, first you have to go ahead with amendment of the memorandum. Once you amend the memorandum, you got the power, then you can do the things, whatever you want. Okay. Now, fifth clause is the capital clause. So this clause will not be there in a company limited by guarantee without shares. But wherever there is a company which is having a share capital, capital clause will tell you the amount of share capital with which the company is to be registered and the division thereof into shares of a fixed amount and the number of shares which the subscribers to the memorandum will agree to subscribe, which shall not be less than one share. One share is the minimum requirement. And the number of shares each subscriber to the memorandum intends to take indicate opposite to his name has to be mentioned. In case of one person company, the name of a nominee has to be mentioned. This is what is the capital clause. Then there is a subscription clause. Subscription clause is nothing but here the list of subscribers to the memorandum is mentioned. Their details are mentioned and their signature is mentioned, as well as their number of shares which they are subscribing, that is also mentioned. 7th and 8th clause are meant for OPC, one person company, and that is there in that particular table which mentions about OPC. So this is the 5th clause. So the 5 clauses which are there for major important 5 clause: name clause, state. Then can you tell me which was the third one? Third one is object clause, then liability clause, and then capital clause, and then towards the end subscription clause, right? So these are the different clauses. Now there is something which is important after memorandum of association is articles of association. Section 5 of the Companies Act talks about articles of association. And what is articles? Articles of association is basically the regulations or rules of regulations for management of a company. It is a detailed functioning of a company is mentioned there, that how they will function, what would happen to the rights of the shareholder, what would be the duties which will be there for the directors. These are the things which are mentioned in the articles of the company. The articles shall provide many things which are prescribed. So if you will see, there are different tables for articles as well. Table F, G, H, I, J in Schedule 1 lists the different types of companies, articles which has to be provided. One thing I wanted to mention to you people here, that if a company does not provide the provisions relating to the articles or memorandum which is mentioned in their tables, particularly articles. So say, for example, a company has provided for articles, but they have missed something. So in those situations, table F may be referred. So table F applies to those particular, companies for articles, functioning of that. Now, if you will see here in articles very, very clearly has to, mention some additional matters which can be mentioned by the company. So you have mentioned table F is the basic table, but if you want to mention something more or you want to have some more provisions, but one has to remember that you cannot mention anything in the articles which goes contrary to the memorandum or the act, right? So it has to be within that boundary, but you can mention things for running of your company. Now, company is free to adopt any of these regulations contained in the modern articles. Now, in case of a company which is registered after the commencement of the act and they do not exclude, modify regulations contained, as I told you, this is a default application of the articles of association provision. Now, nothing in this section shall apply to articles of companies registered under the previous company law unless amended under the act, right? So this is a very, very important provision. That's a nice diagram, Anirudh. This is how it works. So here, basically, articles of the company registered any previous company law unless amended under this act. So previous company law, if some articles are already existing, then that will continue unless the board decides that, okay, we have to change this. Okay. Now, in articles, there is something which is referred to as entrenchment provision. And this is a new provision under the Companies Act 2013. They have provided for entrenchment provision. And this is kind of a, what you can say, is a lock-in kind of a thing. Or you can say is an additional restriction given in case of private companies or private companies particularly. And if you see, the articles may contain provision for entrenchment to the effect that the specified provisions of the articles may be altered only if conditions or procedures that are more restrictive than those applicable in case of special resolution are met or complied with. So there may be more, conditions. I'll give you an example. So say there is a requirement of a special resolution. So this entrenchment provision says, okay, fine, special resolution is okay, but we want that at least, 75, at least 80% or 90% of the directors should also agree to this, or board should be unanimous in this particular decision for change. Now, this is something which is an entrenchment position. So this is a requirement. This is something which is provided to give additional, what you can say, measure for making alteration stringent, as Avinash pointed out. Yes, very, very, very true. Now, the provisions of entrenchment which has been referred shall only be made either on formation of a company or by an amendment in the articles, wherein everybody has to agree. All the members of the company has to agree in case of private company, and in case of public company, a special resolution has to be passed on. Special resolution requires how much percentage of vote? Yes. Oh, very nice. So we require this much of a percentage, this much people should agree, then only there will be a special resolution. Now, where articles contain provisions for entrenchment, whether made on formation or amendment, the company has to give notice to the registrar of such provision in such form and manner as may be prescribed. So there is a, if articles of association, anyways you have to file, but if there is an entrenchment provision, then in those situations, a special mention has to be done to the registrar to tell him, so that he will mark that particular document accordingly. So subsequent changes also will require similar kind of a procedure. So you cannot, once there is an entrenchment provision, then that has to be there. You cannot change that unless everybody agrees in case of a private company, or there is a special resolution in case of a public company. Table F, as I told you, is an example of articles of association. There are about 91 clauses in article of association table F. And it talks about many things. It talks about interpretation. It talks about share capital and variation of its rights. It talks about lien. It talks about calls on shares, how it has to be made. It talks about transfer of shares, how it has to be made. It talks about transmission of shares. What is the distinction between transfer and transmission of shares? Any one of you? Transfer and transmission of shares. Aisha, you have talked about entrenchment. Entrenchment basically means strict condition as it is there. Transfer to share when transfer from one person, and transmission to legal heirs. Very good. So transmission happens in case of a death of a person. That is basically the procedure for transmission. Transfer in a general situation. Then forfeiture of shares, when the shares will be forfeited. Then alteration of capital, capitalization of profits, then buyback of shares, general meetings, how to be conducted, how the proceedings of the general meeting will happen, adjournment of meetings, what are the process, what is voting right, how proxy will happen. All these things are mentioned in the articles of association. What would be the board of directors? What would be the proceeding of the board? Who would be the CEO, manager, company secretary, chief financial officer? These are all known as, there is a word for them together. What is that? Yes. Can you tell me? Yes, KM. That is key managerial person. Very good. You people are all intelligent. I am very happy. Then there is a requirement of the seal. So there is a seal which is required. And now I would tell you this seal was a common seal was again one of the feature of a company, but this feature has now been taken away. So common seal is now not a mandatory requirement or a feature. In articles of association, there has to be a common seal. As you can see here in this particular, right side corner, this is a seal. So generally in documents, this seal is put across and somebody signs. This is called the seal. Dividends and reserve, how that will happen, accounts, winding up, indemnity, all these provisions are there in articles of association. Changing of articles of association and memorandum of association is no, banks and many other companies also use it, Hardik. So if you will see the official documents of different companies, they definitely have a seal. So they take that particular seal. They have that particular seal for document. But it is not a requirement under the law now. Previously, this used to be filed before the ROC. Now, if you will see the changes or alteration in memorandum and articles of association, we will have a look at it in our next class. Today, we will talk about something more, and that is registered office. Section 10 tells you about the effect of memorandum and articles. As I told you before, there is a constructive notice. So memorandum and articles basically puts everybody on notice. Whosoever is dealing with the company, they will be dealing in knowledge of that information. However, you will see that memorandum of association and articles of association, they create a legal relationship also. And one of the legal relationship here is that members are bound to the company, right? So all the members who are subscriber or who are members of the company are bound to the company. Bound to the company for what? Bound to the company for the unpaid shares. This is one. Second, bound to the company in relation to a contract. Like, for example, they get a notice to attend an annual general meeting. It is not mandatory for them to attend, but it is an obligation. They should attend. These are the requirements. So there is a relationship between a company and its members. Similarly, company is bound to its members. Okay, this is a more onerous relationship where the company has to give a notice of meetings. They have to answer queries of members. There is a particular set of percentage of members who can file petitions. So this is a relationship between company and members. By virtue of a common hub and spoke model, or you can say by virtue of this whole agreement, memorandum of association and articles, members are also bound inter se to each other. Okay. So there is a requirement. But these documents don't bind outsiders. Okay. So anyone who is outsider, the company is not bound to them because it is not a document or a contract with outsiders. Unless there is a vendor who enters into a contract with the company specifically. That is a specific contract. So the effect of memorandum and articles is that everybody whosoever is associated with the company as a member gets bound in their relationship with the company with the member, and members amongst themselves. Third party or outsiders have no role to play, and they don't have any contractual relationship coming out of this. Okay. Now, there is a requirement of registered office of a company, and this is the last point which we are going to discuss, and quite an interesting point. In our next class, we will discuss about alteration of memorandum and articles, as well as we will do a recap of our previous session. When we talk about registered office of a company shall, within 30 days of its incorporation. Previously, it was 15 days. Okay. After 2018, there is an amendment, and you can see 15 days have been increased because now, as far as registered office is concerned, there are compliances which have increased, right? And at all times thereafter, have a registered office capable of receiving and acknowledging all communication and notices as may be addressed to it. This is a very, very important. This is called registered office. right? Now, registered office in case of IFSC company will be always in the IFSC zone. So there is a specific economic zone. So they have to operate within that zone itself. They cannot operate beyond that. We gave an example of Gift City previously. So anybody who is operating in an IFSC zone, they have to operate within that periphery. They cannot operate in the Indian country. So basically these IFSC is for foreign services, right? Now, the company has to furnish to the registrar a verification of its registered office within a period of 30 days of its incorporation. And the rule which is provided for is Rule 25. And there is a form INC 22, in which they have to give this information, right? This is a very important information which they have to provide. Now, whenever there will be a change of their registered office, it has to be again verified, prescribed manner, and they have to inform this to the registrar, who has to record this in their record. If there is any default in complying with these particular provision, whosoever is in default, individual or director, there is a penalty for 1,000 rupees for every day, including which the default continues up to 1 lakh rupees, right? So how many days they can delay for the reaching maximum penalty? 100. Yes, very good. So 100 days. After 100 days, the limit will be reaching. What will happen after 100 days? It has reached maximum level. Nobody would like to pay 1 lakh rupees. So they will pay by that time, right? Okay. Then I just want to have a view from you. Are you recollecting this picture? You know this about this picture, or have you seen any one of you before? Okay, it is Kolkata. Very nice. It is not Taj, by the way, Meet. It is not Taj. Yes, it is Kolkata. And this is a very famous building that is called Mercantile Building, okay, in Lal Bazaar. Big Bazaar or Lal Bazaar, whatever you say. So it is famous for, yes, Calcutta is by its yellow taxi, you can identify. So this place is a very famous place, and there was a reporting which happened at that point in time, which talks about homing. As you can see, this is 9/12 Lal Bazaar Street, okay, just near to this place, where at single address, there were 315 companies which were registered. You can see 315, then 315. And in Delhi also this has happened. In Hyderabad also happened. At Fortune Monarch Mall, 3rd floor, 307, there were 244 companies registered at the same address. Now, this was a very, very, problematic situation, because previously there was no verification used to happen of the registered office. And that's the reason now there is a requirement of physical verification of registered office of a company under Rule 25B of the Companies Act. Objective is to identify the shell companies, identifies the companies which are vanishing companies, companies which are false companies, which may be committing fraud, which may be committing chit fund business, which may be committing such kind of a problematic situations. To take care of that, now company requires that there has to be a verification of the registered office. And the Rule 25B basically requires the following, that there has to be a verification, and during this verification, 2 independent witnesses from the locality and assistance from the local police has to be taken. ROC may visit the registered office for physical verification in presence of 2 independent witnesses. Then there has to be a cross verification of documents as filed on MCA 21. Thereafter, the ROC is required to take a photograph of the registered office. Nowadays, you take a geotagged photograph, right? And geotag has actually changed a lot of things. And then submission of a report, finally. This is an advanced information, Hardik. I don't think that this will be required for you to learn, but registered office clause is there, basically specifically mentioned there. So for registered office, all these things are required. actually. So generally, you have to understand it. You don't go into the details of the procedure. I don't think Rule 25B will be required for you. No, I don't think that. Yes, you have to stick to the section. Rule 25B, Rule 12, Section 12, yes. And there is no restriction on this, Anirudh, that how many companies can be there on one address. Picture talks about shell companies, right? So it is shell. So just to indicate that shell companies are no more permitted. Okay. So now you are having display of company address. Every company has to now display the address. Okay. And they have to paint this or affix it in front of their registered office and outside of their place of business, which should be conspicuous position, legible letters. This is the requirement. They have to engrave a legible character on its seal if they have the seal. Get the name and address of registered office along with phone number, etc. on their website, email. And if they have letters, bill heads, letter papers, they have to print that, okay, in all official publications. And have its name printed on hundis, promissory notes, bills of exchange, or any such document which is required, provided that where a company has changed its name, then the name during the last 2 years, it shall paint or affix the previous names also. Last 2 years, they have to do that so that people know. And in case of one person company, you have to write this. These are the two examples of the names, as you can see in this picture, right? I hope you are able to see this. These are the two companies. One is a private company and the other one is a public company. While I was searching this, I came to know Barbecue Nation is a public company. Huh? It is situated in which place? Can you tell me where it is situated by looking at CIN? Barbecue Nation. Karnataka. Very good. And the other one? Punjab. Right. So if registrar has reasonable cause to believe that the company is not carrying on any business or operations, he may cause a physical verification to be done. So it can be done by registrar at any point in time. And if they found that, yes, there is non-compliance of this provision, they can take action for removal of names of companies from the register of companies. This is what is the provision saying, right? So that's it. I think change of registered office. So if special resolution is passed, then you can change the registered office. If you are doing a registration which has to be changed from one ROC to another ROC, which can be situation only in case of two states, there you need to have a confirmation from regional director. In case of Maharashtra and in case of Tamil Nadu. And whenever you make an application to the, after the special resolution, 30 days are provided. Within 30 days, the result, the information will be given to you. And after the change, you have 60 days to file this to the registrar of companies. And registrar of companies has further 30 days to register this change. So this map, you are able to see the regional directors, northern, eastern, northeastern, northwestern, western, southeast, and southern. These are the regional directors with their respective jurisdiction. After the registered office is changed or name is changed, memorandum is changed, they will issue a fresh certificate reflecting those particular changes, right? So this is the overall, about the registered office. Any other points which you have? Ritika, I think you have got a sufficient good notes shared by ICAI already, right? I have gone through your BOS notes. That is quite sufficiently detailed. I would suggest you read that, and as well as if you have recording of these particular sessions, you can again revisit them. Or you can see the presentation. I have shared my presentation. This one also I will share. You can, look at them and then read the provisions. This is what is the requirement. Can we change ROC state-wise? Yes, you can change from one state to another state. The procedure is a bit longer, where you have to take permission from regional director. So that is the requirement. And there has to be no objection also given by the existing ROC. So you can always change. So freedom is there. Which article of the Constitution gives you that freedom? Right? Constitution Article 19 gives you that freedom to do your profession wherever you want in the country. Okay. Right. Now, questions. I would be happy to take questions. I would just stop here because I have a couple of things which I could discuss now, but I think we will talk about this alteration in our next class because it will become too much of information for you people. Yeah. Okay. You did not get private company state. Why not? It is there. You see. Private company, you can see CIN number, PN, Punjab, right? And U is unlisted. And here you can see L is listed, right? This FTC is wrongly written. It should be PTC, that is private company, and this PLC is public. Okay, Nayan, I hope you could find. Right. Any other questions? Questions or clarifications you people have? I'll be happy to answer. Okay. Real life examples of entrenchment provisions. Okay. Real life examples of entrenchment provisions. See, it is a new provision, 2013 Act, it has come up. So any case studies, I don't recollect right now. But if you read the Memorandum of Association or Articles of Association of latest formed companies, there you may find this particular provision. What is entrenchment provision? Entrenchment provision basically is saying that the basic restrictions which are mentioned, they are there. But in addition to that, if you add few more restrictions or you create some restriction for changing the articles of association in future or adding additional requirements for changing the articles of association in future, that is what is retrenchment, right? So that is the requirement. I could not get your point. SEC, what was that point? 30 days, 60 days, that particular slide basically is telling you that confirmation of this has to be coming from whom? Change in the registered office is the regional director, right? So regional director takes 30 days to confirm that and he informs you after your application. You have 60 days to send it to the ROC for registering it because ROC will register. Permission has been given by regional director, but registration has to be done by ROC. And then within 30 days, registrar has to register that particular check. This is what is 30, 60 and 30 days under 12.6. I hope this is clear. Unanimous means together, all of, or means everybody agrees. That is called unanimous. There is no dissenting opinion. Okay, Shruti, noted. I actually wanted to, these are notes. So this will be kind of a notes for you. So that is why I wanted to not have plenty of slides. And this information can be there with you, which you can read. That is why I have kept the font a bit slow. But nowadays, if you are using your mobile, you can increase that by like this, or the font can be increased. So there are facilities. So I hope you people are using your laptop or mobile. So you can always, increase the size of that font. Yes. So, see, registered office can be at any place. Incorporation can be at any place. There is no restriction on that. It is not necessary. As I told you, Article 19 gives the power to you to have establishment at any place. Section 7. Okay. Section 7 talks about incorporation, basically. It is a long section. Please refer to my presentation, which I have given, on Monday. You will get information about that. Any specific question if you have on Section 7, Hardik, I will be happy to answer. Let me check the portal as well if there are any questions. Yes, Mr. Gerald, I have answered this question while taking the session. Whenever a Section 8 company gets wind up, either it gets merged with an existing Section 8 similar objective company, or the amount goes to the Insolvency Bankruptcy Fund of the India. Okay. Unmute, Hardik. Okay. Yes. Go ahead, Hardik. I think I have unmuted you.
Sir, I am asking that today's first slide, in which the furnishing of a false information or incorrect information or suppressing of material fact is there.
Okay. Coming. That is basically dealing with furnishing of false information, Hardik. So
Sir,
anybody who furnishes the false information, they will be tried under that. So they will be, considered as corporate fraud. That is what that section says, basically. So it says it is basically a what you can say, deterrent for the people to not give false information. That is the purport of it. Any specific question still? Let me take you to that particular section. This one you are talking about, right? Yes. Any question? Specifically what you want to say? Okay. Post and during incorporation. So whatsoever is the situation, either, okay, give me a second.
yes,
Yes,
sir.
ask Hardik.
Sir, in that there are no during incorporation process and post incorporation processes there. But sir, in during incorporation, 447 is there. But sir, during incorporation, if the ROC gets to know that there is any fraudulent activity, then first of all, why will he register the company?
No, see, point is that during incorporation, if they will not register. But again, that does not mean that they will put the person who have given false information off the hook. He has a power to initiate a corporate fraud case, which he will do if he has that particular power. He has both the powers. He can deregister them. He will not permit them. Or in case he has wrongly registered, then he will move the tribunal and all these orders can also be passed. So there are multiple options which are available to the regulator.
So sir, we can say that if the company is not registered, then 447 will be applicable. If registered, then tribunal will provide the
No, not
solution.
necessary. Not necessary. Even if they say, for example, if it is registered, they will move ahead with tribunal. But even if it is not registered and they get that particular information, can a fraud case not be filed against them? It can be always filed. Under Bharatiya Nyaya Sanhita, somebody, registrar can file a case if they want.
Okay, sir. Thank you, sir.
Yeah, right. Okay, Praveen, you have a question? Go ahead. Regional director and registrar, Omkar, the difference is regional director are for the region. As I showed you in the map, there are regions and few registrar of companies. It is the superior authority of registrar of companies. That is what is the difference. Yes, yes. In all these cases, there will be a chance of, notice. Nobody will be given a order without hearing. This is the basic requirement of principle of natural justice. Yeah. Yes, there are 7 RO. No, not 7 ROC, 25 ROC, 7 regional directors. Registration and incorporation. Incorporation is done by registration. So that is the thing. So for incorporating a company, you have to register it, right? And register not only number of things has to be registered, right? No, they are government employees. These all ROC and RDs, these are all government employees directly under Ministry of Corporate Affairs. Yes, you are right. Sure. Registration is a process. Yes. Any more questions? Let me check the portal. Okay, Aisha. Aisha, it seems that you came a bit late because I dealt with constructive notice in quite detail. Yes, Pranav, I will upload the PPT. Not, if not possible today, tomorrow morning, definitely. Yes. Yes, Vibhor, you are right. Shell companies are companies which are formed for not doing business, but just like that, to park illegal money or maybe to do business at a later point in time, or it is just formed for doing some illegal activity. And these are all shell companies, right? Right. Okay, I will try for the questions. Are you people not having a model question paper available with you? I think in your portal, it must be there somewhere. In BOS also, I think there is a document. You have mock test papers, right? Case-based question. Okay, fine. I'll get some case-based questions. Yes. Okay. I'm not talking about CIO. Okay. If there are no further questions, thank you. It was a pleasure interacting with you all. Yes, Aisha, you can start a company in another state. You have to follow the process to, change from one state to another state. Okay. So Nisarg, I think we are done with this. Onkar, we will get back to on this particular how to write, questions and answers. This we will discuss maybe in our next class. Okay, for this particular chapter. So the remaining time, once I cover everything, in the remaining time we will discuss about this. Okay. Thank you then. Yes, yes, yes. Okay. Thank you.